Right to bail and against excessive bill bail. A security such as cash or a bond. Especially a security required by a court for the release of a prisoner who must appear in court at a future time, when a matter of right, before conviction. Bail is a matter of right when the offence charged is punishable by any penalty, lower than a reclusion perpetua when a matter of discretion, or life imprisonment that is. Bail will be denied if the evidence of guilt is strong. Enter. When bail shall be denied or cancelled. If the penalty imposed by the trial court is imprisonment exceeding 6 years, the accused shall be denied bail, or his bail shall be cancelled upon a showing by the prosecution, with notice to the accused, of the following or other similar circumstances. 1. That he is a recidivist, quasi-recidivist, or habitual delinquent, or has committed the crime aggravated by the circumstance of reiteration. 2. That he has previously escaped from legal confinement, evaded sentence, or violated the conditions of his bail without valid jurisdiction. 3. That he committed the offence while under probation, parole, or conditional pardon. 4. That the circumstances of his case indicate the probability of flight if released on bail. Or 5. That there is undue risk that he may commit another crime during the pendency of the appeal. Imposition of excessive bail. Imposing bail in an excessive amount could render meaningless the right to bail. Presumption of innocence. It is a basic constitutional principle, fleshed out by procedural rules which place on the prosecution the burden of proving that an accused is guilty of the offence charged by proof beyond reasonable doubt. Corollary terrato. Conviction must rest on the strength of the prosecution's evidence, and not on the weakness of the defence. Hence, the accused need not offer evidence on his behalf, and may rely on the presumption entirely, should the prosecution fail to overcome its burden of proof. Right to a speedy trial. The right to a speedy trial means that an accused person has the right to be tried in a reasonable amount of time. The right of the accused to a speedy trial, and to a speedy disposition of the case against him, was designed to prevent the oppression of the citizen by holding criminal prosecution suspended over him for an indefinite time, and to prevent delays in the administration of justice by mandating the courts to proceed with reasonable dispatch in the trial of criminal cases. Such right to a speedy trial and a speedy disposition of a case violated only when the proceeding is attended by vexatious, capricious and oppressive delays. The inquiry as to whether or not an accused has been denied such right is not susceptible by precise qualification. Right to an impartial trial. Impartial, it means not partial or biased, treating or affecting all equally. Fair trial, a trial that is conducted fairly, justly and with procedural regularity by an impartial judge, and in which the defendant is afforded his or her rights. Right to a public trial. The trial must be public. It possesses that character when anyone interested in observing the manner a judge conducts the proceeding in his courtroom may do so. There is to be no ban on such attendance. His being a stranger to the litigants is of no moment. No relationship to the parties need to be shown. The thought that lies behind this safeguard is the belief that thereby the accused is afforded further protection, that his trial is likely to be conducted with regularity and not tainted with any impropriety.
The right to meet the witnesses face-to-face. To meet the witnesses face-to-face is the right of confirmation, subsumed in this right to confront is right of an accused to cross-examine the witnesses against him or her to propound questions on matters stated during the examinations are connected with it. The cross-examination may be done with sufficient fulfillment and freedom to test the witness' accuracy and truthfulness and freedom from interest or bias, either reverse, and to elicit all important facts bearing upon the issue. Her to be informed of the nature and cause of the accusation against him. The constitutional right to be informed of the nature and cause of the accusation entitles the defendant to insist that the indictment apprise him of the crime charged with such reasonable certainty that he can make his defense and protect himself after judgment against another prosecution on the same charge. Right to compulsory process. It is the right of the accused to have a compulsory process to secure the attendance of witnesses and production of evidence in his behalf. Example, issuance of subpoena. A process directed to a person requiring him to attend and to testify at a hearing or trial of an action or at any investigation conducted under the laws of the Philippines or for the taking of his disposition. There are tokens of subpoena. 1. Subpoena duces tecum. It is used to compel the production of books, records, things, or documents that are any specified. 2. Subpoena ad testificandum. It is used to compel a person to testify. Right to the writ of habeas corpus, meaning it means you should have the body. Purpose of the writ. The writ of habeas corpus was devised and exists as a speedy and effectual remedy to relieve persons from unlawful restraint, and as the best and only sufficient defense of personal freedom. It secures to a prisoner the right to have the cause of his detention examined and determined by a court of justice, and to have a certainty if he is held under lawful authority. Suspension of the privilege of the writ. The privilege of the writ of habeas corpus shall not be suspended except in cases of investigation or rebellion, when the public safety requires it. Right against self-incrimination. It is a right not to be compelled to be a witness against himself. A person's right against self-incrimination is enshrined in Section 17, Article 3 of the 1987 Constitution, which reads, "No person shall be compelled to be a witness against himself." Applicability of the right. The right against self-incrimination is accorded to every person who gives evidence, whether voluntary or under compulsion of subpoena, in any civil, criminal, or administrative proceeding. Purpose of the right. It secures the witness, whether he be a party or not, the right to refuse to answer any particular incriminatory question, i.e., one of the answer to which has a tendency to incriminate him for some crime. When to invoke the right. The right can be claimed only when the specific question incriminatory in character is actually put to the witness. It cannot be claimed at any other time. It does not give a witness the right to disregard a subpoena, decline to appear before the court at the time appointed, or to refuse to testify altogether. The witness receiving a subpoena must obey it, appear as required, take the stand, be sworn, and answer the questions. It is only when a particular question is addressed to which may incriminate himself for some offense that he may refuse to answer on the strength of the constitutional guarantee. Right to political beliefs and aspirations. Section 18, Article 3 of the Philippine Constitution. It states that no person should be detained solely by reason of his political beliefs and his aspirations. Political belief refers to a belief or view that has some bearing on issues dealt by government. Political aspiration is an essential component of politics. Aspiration structures political action. It articulates goals, affirms identities and values, generates motivation, and can help to facilitate agreement in complex issue areas. Right against involuntary servitude. Involuntary servitude denotes a condition of enforced compulsory service of one to another, or the condition of one who is compelled by force, coercion, or imprisonment, and against his will, to labor for another, whether he is paid or not. Rule. Now involuntary servitude in any form shall exist, then exception to the rule as a punishment for a crime whereof the party shall have been duly convicted.